Hi there, my name is Stephen Nicholas, a Stetson Law student, and I work with Community Law Program's Amendment 4 team to help Pinellas County citizens restore their voting rights, restore their driver's licenses due to unpaid fines and fees, and to seal and expunge their criminal records. Today on Fellowtalk Friday, we're going to talk briefly about the road to a constitutional amendment. Specifically, I'll be talking in terms of Amendment 4, which restored the right to vote for former felons who have already served their time. First, some background. Before 2018, Florida was one of 4 U.S. states that enacted permanent felony disenfranchisement, affecting 1.7 million felons. This means we were one of only 4 U.S. states that permanently blocked the right to vote for those with a felony conviction. Florida's disenfranchised felons constituted 10% of the adult population and 21.5% of the adult African American population. In March of 2017, 7 former felons filed a lawsuit against the state of Florida in the U.S. District Court for the Northern District of Florida. In this case, Hand v. Scott, the plaintiffs argued that Florida right restoration process was unconstitutional. In April 2018, District Judge Mark Walker ruled that Florida's process for seeking restoration of voting rights was unconstitutional because it relied too much on the personal appeal to the governor and his cabinet. The state appealed to the U.S. Court of Appeals for the 11th Circuit, which stayed Judge Walker's ruling. Floridians for Fair Democracy, which was led by Desmond Meade, a voting rights advocate, successfully gathered more than 799,000 certified signatures in their petition drive to get Amendment 4 on the ballot, just a week before the deadline to reach the required total, which was 766,000. This group, along with others like the ACLU, had attempted unsuccessfully to get Amendment 4 on the ballot in 2016. They covered the entire state, all 27 congressional districts, collecting signatures. The Florida Supreme Court approved the language of the proposed amendment in April of 2018. In order for the ballot initiative to be added to the Constitution, it had to be approved by 60% of the voters. The initiative was sponsored by the Florida Rights Restoration Coalition, FRRC, with the support of the ACLU, Christian Coalition of America, and Freedom Partners. The Amendment 4 ballot initiative stated the following: this amendment restores the voting rights of Floridians with felony convictions after they complete all of the terms of their sentence, including parole or probation. The amendment would not apply to those convicted of murder or sexual offenses, who would continue to be permanently barred from voting unless the governor and cabinet vote to restore their voting rights on a case-by-case basis. In November of 2018, Amendment 4 passed with 64.55% of voters in favor. Amendment 4 went into effect on January 8, 2019, opening up eligibility of 1.4 million returning citizens to register to vote. However, that's not the end of the story. Almost immediately after the amendment passed, Governor Ron DeSantis signed into law SB 7066, which proved to be another roadblock in the fight for felon rights restoration. It required any felons that would like to vote to have first paid off their fines and fees on top of serving their time. You'll learn more about SB 7066 and the current state of Amendment 4 on the next Fellowtalk Friday.